In the last few videos, we have spoken about cross-border data transfer as well as standard contractual clauses. In this video, we are going to have a quick look at how practically you can implement the standard contractual clauses when you are moving the data out of European Union. Welcome to my YouTube channel where you have been finding new content on data privacy on a daily basis. And as I mentioned, we are going to get into a bit more detail about standard contractual clauses. What are these? You can say these are sort of a legal tool that the European Union has formed. They want to protect the personal information of their citizens when that information is moving out of the European Union as such. Why they want to protect it? Well, that's their information. They have all the right to do that. They follow GDPR. They follow the compliance rights. So when the movement of information is outside to a country where the data protection, personal information protection laws are not very stringent, then there are supposed to be some clauses in the agreement signed between the companies, between the two countries, to ensure that the personal information of European citizens is taken care of even if it's outside the European Union. What are the protocol templates, the right template that you need to choose? You need to decide which flow of data is it for you. It could be a controller to controller, wherein at the source also the company is engaged into collecting and storing information, not processing immediately, and even at the destination the purpose is more of storage of the information. It could be collected to a processor, you collect it, stored, but you are getting a third party processing done from outside your country, which is a non-European country. It could be a processor to processor, whereas both the source within the European Union and the destination out of European Union, both are engaged in the activity of processing personal information. Or finally, it could be a processor to controller, where the company in European Union is engaged into processing personal information and the destination is engaged into only just storing the personal information with them and not into processing. It could also be that the processor is outside and is sending the information back to the controller inside to the European Union. So first you need to choose which type of relationship at that particular transaction you are doing, and then you have to perform a data assessment, which is data transfer impact assessment, because you are transferring data outside the country. You need to assess the risk. You need to check whether the destination country really has some government surveillance or some regulators or some laws that take care of the personal information they are collecting and processing. You have to look into their laws and practices. And if you find that adequate practices are not followed, then you need to use your own safeguards for your personal information. What are those safeguards? These could be encryption, these could be anonymization, and any other privacy enhancement technique that helps you protect your privacy of your citizens. You need to review and incorporate these clauses into the contracts, incorporate them into the agreements, ensure that both the parties at the source as well as at the destination are legally bound, right? They are both legally bound that they are going to take care of a minimum level of protection of the information, which minimum does not mean that it is not protected. Minimum means they are going to follow some basic norms when handling the personal information of a European citizen outside Europe. Both parties should understand their obligation, and the key to their obligation is protection of the information as well as being available to respond back to the regulators and the regulatory authorities as and when required. They should ensure that there is a protection to the rights of the data subjects in the country. And the data subject rights that are critical in this case are the right to accessing data, the right to correct the data or get it corrected, and the right to delete your information which is being processed outside the European Union. The final step in this entire practical implementation is finally implementing security and documentation. If you think your data is not going to be secure, or if the destination is not following any security laws, then you should make sure that the transfer is secure using HTTPS and the destination has adequate encryption and access controls at least to begin with. Appropriate security policy. Staff education for their staff to ensure that their staff takes care of the information well. Process monitoring, what processes are being followed by them. So staff education does not necessarily mean only telling them how to encrypt the data, but also what processes are they following and how are they handling them. Perform regular process audits and maintain the documentation for all the processes and all the incidents that are happening in your organization. You need to maintain extreme transparency with the data subjects. GDPR focuses on data subjects a lot, right? So the country is processing European Union citizens' data also has to take care of the data subjects' rights and adapt to the regulatory changes happening both in the source country as well as in the destination country. That's what I have on the practical implementation of standard contractual clauses. I hope you like my content. Please press the bell and the like icon. Subscribe to my YouTube channel and share your feedback in the comment section. Thank you.